On a roll and got some more time. Video 12, Categorical Demands Upon the Laws. As expressed with the paper titled Classification of Property and Conceptions of Ownership in Civil and Common Law by Barbara Pierre, she writes, the English law of property responded to the change in the social order by the modification of tenures and the introduction of the concept of estates. Further on, she continues with expressing this. The modification of the tenure culminated in A, their reduction in number to one, free and common soccage, B, the commutation of their incidence to the payment of money, and C, to the increase in the power of the tenant over land, unquote. We touched on B in past videos, and so at this time, I'm not sure I will ever dissect the topic of incidents in future videos, whereby I'll spend any time in further examining the Lord's rights over the tenant under the personal loyalty scheme, which entitles the Lord to control wardship and marriage, fines for alienation, and rituals and practices surrounding homage and fealty, which in consequence projected a duty in the Lord through warranty and defense. And as for A and C, A is premature currently concerning our eventual future destination concerning the tenure system after the Abolition of Tenures Act of 1660, and so discussing the introduction of free and common soccage would be, at this stage, not beneficial. Which leaves us with C. Topic C, to do with the increasing power over land by the tenant, is where we can then begin, as we are still investigating the origins of the feudal land tenure system, which established the basis of rights over the use of land, whereby English law is most certainly the evolution of rules over land, subject to a hierarchical right to hold the land interest thereof, not ownership in its strictest sense, as we've learned, but rather concerning a tenant's control over an interest in land called an estate. Now returning to the feudal land tenure system, immediately under the military tenure accepted by a lord, he sought to get the most out of each tenant, juxtaposed to the tenant wanting to part with as little as possible in order to receive a copyhold or other interest in land. These combating egos resulted in the type of rights to land through the capacity of a tenant that we enjoy today, essentially holding a right to a third level of use to land, to which now, I surmise and have made comments on, is being clandestinely guided into a fourth level of property rights, i.e., own nothing and be happy, which upon the face of it, looking to the strictest sense of the idea of ownership, society has only ever acted upon the status of a citizen, which is foundationally a volunteer position representative of an uncompensated quasi-trustee, as opposed to being held responsible as an allodial owner. In the beginnings of the feudal land tenure system, a specified area of land was delegated by the concept of tenure, recorded in a book of AD 1086 called the Domesday Book, which did a survey of all landed property captured in the 11th century, including making for account their current use, which basically distributed land through the characteristic of quality called freeholds. A man's estate was a freehold in quality, which is determined by the type of tenure and his status. The next level of evolution in tenures was coming to understand that these tenures could be measured quantitatively, meaning based on duration as opposed to area. So the value switched from trying to control the tenure through defined periods, such as leaseholds, to now encompass the potential length of time that these new quantum-wise estates may last, as described by Boralaskin. From here, we move into the foundational conflicts that ensued as a result of either lord or tenant wanting not only more power to control while they hold a freehold or non-freehold estate, but also, more importantly, what was to remain in their families after death. So wanting to create rules over inheritance. Before we even consider the important topic of inheritance, being the catalyst, as far as I'm concerned, for today's right of season over fee simple absolute, I will touch on the prime drivers which demanded resolution, and so from these basic conflicts emerged the laws after much debate. This underpinned in reason from desires of the executive to maintain peace and order within the realm. Boralaskin, from his book titled Cases and Notes on Land Law, expresses three key drivers from which emerge three different areas of law. Bora writes, these classifications that demanded settlements were 1. The conflict between the lord and his tenant, 2. The conflict between the lord and the presumptive heir of the tenant, and 3. The conflict between the tenant and his presumptive heir. From these classifications, we can begin to trace and assign relevant reactions that has subsequently emerged from these core conflicts so as to arrive in an observable settlements, now found in case, acts, and statutes that serve to secure one's own rights to an estate in order to lessen the potentiality for future conflict. The first type of conflict developed laws that enforce rules over tenures and incidents, while the last two conflicts focus mainly upon rights to become attached to the estate itself, in the interest of the tenant, namely matters of inheritance and alienability. Right to pass on a tenant's interest to his heir, recognized as a developing estate interest under the category of quantity of estate, that matter of negotiation between the lord and the presumptive heir of the tenant. Now remember also that there is no heir to the living, evolved into what we know as the laws of inheritance. From the laws of inheritance, a modification of the personal nature of feudalism was curtailed to the extent of the tenant's interest not ending at his death, and later, through quia emptoris, the right of the tenant to alienate his land completely and so be free of the obligation attached to the property interest. Before I end this video, by the way, any donation is greatly appreciated for me creating this content and creating this messages or information about the law. So to help you lessen the amount of research that you have to do, it can be found directly below as a means in which you can kindly donate. But as I go back into what I've just expressed, that the whole purpose was to, through quia emptoris, is remove the obligation of the tenant. And so if we have that as a foundation, we then have to look at, well, can we also be removed of the obligation? Now, in order for law to be perfected, there must be a means to express a right to remove oneself from any burden which is no longer of a benefit, and if ever it was. We must be with the right to now not be bound by a social order, which is not enforcing a direct action upon us as a human. Remember, they don't record us, they record the event. But rather that the English law system is expecting a performance of an obligation embedded within the rights to the use of land. Yet, we are born with dominion, so without obligation to English law. And with that thought, subscribe if you haven't done so already, and click the like button if you care to do so. If you do find this content of value. And by all means, share. Because, like I said, and if you're starting to probably comprehend as you're, scrolling through all the different videos on how to, deal with your current interest, it is starting to become more apparent that it is essentially the misunderstanding of law that projects our reality into an area that we do not want to, continue to fight within. We have the law. The public system does not. So, essentially, why do we continue to look into the public system when that is not what we truly seek, which is full remedy from those burdens that are attached to the English law system. Have yourself a great day.